Senator John Neely Kennedy stood firmly at the podium in courtroom number 3 of the United States Supreme Court, his meticulously tailored navy suit accentuating a composed demeanor amid the majestic marble columns behind him. Just minutes earlier, Chief Justice John Roberts had interrupted Kennedy's argument with a startling challenge. "Senator Kennedy, I fear that your eloquent Senate speeches may struggle to meet the legal complexities of this court." Those words stunned the courtroom. Law clerks exchanged glances, seasoned attorneys sat up straighter, and reporters scribbled furiously. But Kennedy, the conservative politician from Louisiana, armed with law degrees from Virginia and Oxford and years of quiet constitutional study, remained unshaken under the scrutiny of 9 justices and hundreds of attendees. Chief Justice Roberts, with his Harvard pedigree and 2 decades leading the Supreme Court, believed he could expose the legal shallowness of a populist politician. Yet Kennedy, equipped with a fresh legal framework on the Second Amendment grounded in deep historical research from early militia laws, was about to turn this prejudiced jab into one of the most memorable arguments in decades. This was no ordinary trial. It was a moment for Kennedy to prove that legal brilliance could emerge from the most unexpected places and potentially reshape how America understands constitutional rights forever. Before diving into the story, comment where you're watching from and don't forget to subscribe so you won't miss the latest stories. Inside the courtroom, each footstep echoed as if rebounding off the cold marble. The atmosphere here was always solemn, but today felt different. An invisible current coursed through the room as Senator John Neely Kennedy stepped to the podium, his gaze sweeping across the 9 justices from Thomas's stern visage to Kagan's piercing stare. The Supreme Court chamber, with its vaulted ceiling and hallowed air, seemed to hold its breath as he spoke, his voice carrying a distinctive warm, approachable yet incisive tone. "Mr. Chief Justice, the Second Amendment is not a decoration. It is an ironclad commitment that the people may bear arms for self-defense, not just at home but on the streets, as the founders intended." He opened a thick binder, his fingers gliding over handwritten notes. History shows that from militia laws in Virginia to regulations in Louisiana in 1810, the right to openly carry firearms was taken for granted. James Madison, in a lesser-known note, wrote that this right safeguarded the spirit of independence of the people. Kennedy paused, noticing Justice Alito's slight nod, but Roberts remained upright, brows furrowed, clearly unconvinced. "Senator Kennedy, I appreciate your passion, but this court does not run on folksy tales or selective quotes. Your argument seems to sidestep United States v. Miller, where the court held that the right to bear arms pertains to an organized militia. How do you address that?" The question was a thrust, aimed not just at the argument but at Kennedy's credibility. Spectators murmured. A reporter from The Advocate leaned forward to jot notes, while Louisiana farmers in the audience exchanged anxious glances. Kennedy didn't flinch. He tilted his head slightly, as if considering a simple query from a Baton Rouge voter. "Mr. Chief Justice, I don't dodge Miller, but with the court's permission I'd like to clarify the context." He turned a page in his binder, his voice calm yet magnetic. In Miller in 1939, the court did not reject an individual right to bear arms. Instead, it focused on the type of weapon, a sawed-off shotgun unsuitable for militia use. The ruling never stated that the right to openly carry outside a militia doesn't exist. In fact, District of Columbia v. Heller in 2008 clarified, this right belongs to individuals, not just militias. The courtroom fell silent. Justice Sotomayor leaned slightly forward, pen in hand, while Justice Barrett jotted something down. Kennedy pressed on, his voice growing stronger. "Let's go back to history. In 1791, when the Second Amendment was ratified, states like Pennsylvania and Kentucky required citizens to carry firearms at public gatherings to protect the community. In Louisiana, an 1810 law mandated that every free man carry a weapon when out, not just for hunting but for self-defense. This wasn't an abstract idea, it was the reality of the founding era." Roberts, unwilling to relent, interrupted again, his tone now tinged with sarcasm. "Senator, you tell a compelling history, but this court needs legal arguments, not campaign speeches. Do you have specific evidence, beyond local laws, to prove that the right to openly carry is as absolute as you claim?" The question was a jab, implying Kennedy relied on fragmented details lacking depth. Kennedy smiled, the smile of someone confident in their hand. "Mr. Chief Justice, I don't claim this right is absolute, but it is foundational. If the court wants evidence, Look to the Federalist Papers, number 46, where Madison wrote that an armed populace is a shield against tyranny. Or if the court wants specifics, I can cite State v. Chandler from 1850 in Louisiana, where the state court affirmed the right to openly carry as sacred unless there was a clear threatening act. He paused, locking eyes with Roberts. I've read every gun-related case from 1789 to 1860. None deny this right. Murmurs rippled through the courtroom. A young lawyer in the back let out a soft whistle, while a Louisiana farmer whispered to a friend, "He ain't playin'." Justice Thomas, typically silent, raised an eyebrow, his gaze intent. Kennedy, sensing the shift in the room, continued. This court, the Louisiana law challenged today, banning open carry without a special permit, not only defies history but violates New York State Rifle and Pistol Association v. Bruin. That ruling requires gun restrictions to have historical precedent. Louisiana's state has shown none. Roberts, now visibly caught off guard, sat up straighter, his fingers tapping lightly on the bench. He prepared to ask another question, but Kennedy, as if reading his intent, pressed on before being cut off. If the court is concerned about public safety, I agree the right to bear arms isn't limitless, but limits must be based on specific reasons, not blanket bans like this law. In Louisiana, we believe honest citizens shouldn't be stripped of their right to self-defense just because the government wants control. Senator Kennedy, you talk about history, but modern laws face new realities, gun violence, urbanization. How do you reconcile this historical right with today's safety needs? Her question wasn't hostile but a genuine challenge, opening a chance for Kennedy to show his depth. Kennedy nodded, his voice softening but resolute. Justice Kagan, I understand the concern, but history isn't a relic. It teaches us how to protect rights without sacrificing safety. States like Vermont, from the 18th century to today, have allowed open carry without higher crime rates. The issue isn't guns, it's how we enforce laws against crime. Banning honest citizens from carrying doesn't curb violence, it just makes them more vulnerable. The courtroom fell silent again. Senator John Neely Kennedy stood firm at the podium, his worn legal binder open, pages filled with handwritten notes from years of study. His plain Louisiana drawl, seemingly simple, had begun to shift the room's perspective, but Chief Justice John Roberts, seated at the center of the bench, remained unconvinced. His sharp gaze locked onto Kennedy, determined to expose what he saw as a politician's performance rather than a lawyer's expertise. The other justices, from Alito's calm curiosity to Sotomayor's skeptical frown, leaned forward, sensing the weight of the legal duel unfolding. Louisiana farmers and NRA members in the gallery gripped their seats, their faith in Kennedy unwavering but tinged with anxiety. Roberts, seizing the moment, leaned toward the microphone, his voice cutting with the authority of one who had dismantled countless arguments. Senator Kennedy, your references to ancient militia laws are noted, but let's turn to precedent. In United States v. Cruikshank in 1876, this court ruled that the Second Amendment does not bar states from regulating arms. How do you reconcile that with your broad claim of an unrestricted right to bear arms? The question was a calculated strike, designed to trap Kennedy in a web of precedent that seemed to undermine his stance. Murmurs spread among the reporters. A journalist from National Review scribbled furiously, anticipating a stumble. Kennedy looked up, his eyes meeting Roberts' stare with a calm, steely resolve. He adjusted his glasses, his fingers brushing the edge of a yellowed document in his binder. Mr. Chief Justice, Cruikshank is a landmark, but often misunderstood. That case, rooted in Reconstruction, dealt with private militias, not individual rights. The court never said states could outright ban open carry. In fact, it left room for individual rights, which Heller and Bruin later clarified. He paused, letting his words sink in. If the court permits, I'd like to examine the historical record Cruikshank drew from. In 1790, a North Carolina court upheld a man's right to carry a rifle in public for self-defense, absent any threat to others. That wasn't an outlier, it was the norm in early America. The courtroom stirred. Justice Alito, a known Second Amendment supporter, interjected, his voice probing but intrigued. Senator, you argue there's historical consensus, but what about practical limits? States have long regulated concealed carry, even in the founding era. Doesn't that weaken your case for open carry? Kennedy nodded, as if welcoming the challenge. Justice Alito, it's true that concealed carry was regulated because it was seen as sneaky, tied to criminal intent, but open carry was the opposite, the standard. In 1813, A Kentucky court struck down a ban on concealed carry, but upheld open carry as a sacred right to liberty. I've reviewed 32 state court rulings from 1789 to 1850. 29 affirmed open carry as a fundamental right, limited only by clear misuse. Justice Kagan, ever practical, raised her hand, her voice cutting through the room's murmur. Senator, your history is compelling, but today's reality is far different. Gun violence statistics over 40,000 deaths last year demand regulation. How does your framework address urban safety without gutting state authority? The question was weighty, reflecting the divide between textualists and those wary of unchecked weapons. The gallery stirred, some nodding with Kagan, others glaring in defense of Kennedy. Kennedy responded slowly, his voice steady yet persuasive. Justice Kagan, I don't dismiss those numbers, but disarming law-abiding citizens doesn't stop criminals. Look at New Hampshire, where open carry has been legal since the 18th century. Their violent crime rate is half of Louisiana's. The issue is enforcement, not the right to carry. My framework allows states to regulate like banning guns in sensitive places like courthouses, but Louisiana's blanket ban lacks historical basis and fails Bruin's test. He flipped to a chart in his binder. FBI data shows 80% of gun crimes involve illegal weapons, not legally carried ones. Punish lawbreakers, not the law-abiding. Roberts, sensing an opening, pressed further. Senator, you cite state cases and data, but this court rules on federal precedent. In Presser v. Illinois in 1886, we upheld states' rights to regulate militias and, by extension, arms. Your argument seems to cherry-pick history to sidestep this precedent. His tone carried a challenge, suggesting Kennedy's research was more political sleight than scholarly rigor. Reporters leaned forward, pens ready, while a Louisiana farmer whispered to a neighbor, "He'll handle it." Kennedy gave a slight smile, the look of someone holding a winning hand. Mr. Chief Justice, Presser doesn't contradict my position. It addressed organized militias, not individual carry. The court explicitly avoided ruling on individual rights, leaving that door open. If the court permits, I'll point to a lesser-known case, Nunn v. Georgia in 1846. He pulled out a photocopied page, its edges worn from frequent review. Georgia's Supreme Court struck down an open carry ban, calling it a sacred right under both state and federal constitutions. Justice Lumpkin cited Madison's view that an armed populace prevents tyranny. I've traced 18 similar rulings from that era. None support Louisiana's law. Silence enveloped the room. Justice Thomas, typically stoic, leaned forward, his pen still. Justice Barrett, engrossed, asked, Senator, your research is thorough, but how do you distinguish Nunn from modern cases like McDonald v. Chicago, which applied the Second Amendment but allowed reasonable regulation? Kennedy seized the chance. Justice Barrett, McDonald reinforces Heller's core. The right to keep and bear arms is individual. Reasonable regulation, background checks, red flag laws is permissible if historically grounded. But Louisiana's law requiring permits for open carry with vague criteria mirrors the arbitrary bans Bruin rejected. That's not regulation, it's obstruction. Roberts, now genuinely engaged, tried another angle. Senator, your historical journey is impressive, but what of stare decisis? Overturning Louisiana's law could disrupt decades of state regulation. Have you considered the chaotic consequences? The question was quintessential Roberts, testing not just the argument, but its broader implications. Kennedy didn't hesitate. Mr. Chief Justice, stare decisis matters, but not when precedent strays from the Constitution's text. Bruin set a clear standard. Laws must align with historical tradition. Louisiana's doesn't. As for chaos, my research shows 15 states allowing open carry saw no crime spikes. Stability comes from clarity, not overreach. Justice Sotomayor, her expression softening, interjected. Senator, let's talk about Louisiana. Your state has high gun violence. How does your argument protect communities like New Orleans, where guns are a daily fear? Kennedy turned to her, his voice earnest. Justice Sotomayor, New Orleans' pain is real, but disarming honest citizens doesn't fix it. My proposal allows targeted laws like harsher penalties for illegal carry in high-crime areas, but Louisiana's law punishes everyone, from rural farmers to city shopkeepers, without evidence linking open carry to violence. The gallery erupted in applause, quickly hushed by court staff. Kennedy pressed on, presenting his final piece of evidence. I found a 1792 letter from Thomas Jefferson to a Virginia militia leader, urging every man to carry a rifle in public, so the government never forgets its limits. That is the heart of the Second Amendment, not just self-defense, but a bulwark against overreach. The room fell silent, his words sinking deep into everyone's minds. Roberts, his initial skepticism fading, adjusted his posture, his pen hovering over the paper. Kennedy, at the podium, was no longer the underestimated politician, but the focal point of attention, a lawyer reshaping how the court viewed the Second Amendment. His binder, with its worn pages, lay open before him, like a map guiding through a legal maze. The justices, from Barrett's sharp gaze to Thomas's rare calm, were drawn into Kennedy's argument. Chief Justice John Roberts, though still stern-faced, no longer exuded initial doubt. Instead, he listened, his pen scribbling steadily. In the gallery, Louisiana's farmers, shopkeepers, NRA members sat upright, eyes gleaming with pride, while reporters from the Advocate and National Review scribbled frantically, sensing a historic moment. Kennedy, noting the shift in the courtroom, moved to the core of his argument, a new legal framework for evaluating gun laws. He raised his hand 3 fingers up, his voice low but clear, like a professor delivering a lecture. This court, I propose a 3-part test, rooted in the Constitution's text and founding-era practice. First, gun laws must respect the individual's right to openly carry, absent a compelling specific public interest. Second, the government must show clear evidence of direct harm from carrying, not impose blanket bans. Third, any restriction must have historical precedent, as Bruin demands. Justice Clarence Thomas, rarely vocal, suddenly interrupted, his voice deep and weighty. Senator, you emphasize a textualist approach. Can your test be consistently applied across all states, even those with strict gun control traditions, like Massachusetts? The question, though not confrontational, was an invitation for Kennedy to prove his argument's practicality. The courtroom went quiet, all eyes on him. Kennedy nodded, his gaze meeting Thomas's with respect. Justice Thomas, my test isn't one size fits all, but it's flexible enough to honor history. Massachusetts, in 1790, required carrying arms during community patrols, but banned their use to intimidate. My test allows such states to set rules, like banning guns near schools, if grounded in historical precedent. But Louisiana's law, with its arbitrary permits, has no roots in the founding era. He flipped to a note, citing an 18th-century Massachusetts law, prompting a rare nod from Thomas. Justice Amy Coney Barrett, with her meticulous questioning style, raised her hand. Senator, I'm intrigued by how you tie open carry to self-defense. But does this right extend to all public settings, like crowded events where chaos risks are high? Her question balanced legal theory with social reality, challenging Kennedy to clarify boundaries. Kennedy responded, his voice gentle but firm. Justice Barrett, self-defense is core but not absolute. History shows states banned guns in specific settings, like crowded fairs in Virginia in 1800, when disorder was a risk. My test allows that, provided the government proves a specific danger, but Louisiana doesn't. Their law bans carrying in all public places, from rural markets to New Orleans streets, without distinguishing context. He paused, looking at Barrett. Self-defense isn't just a right, it's a human instinct, and the Constitution protects it. Justice Sonia Sotomayor, often skeptical of arguments expanding gun rights, interjected, her voice tinged with concern. Senator, you speak of history, but in cities like New Orleans, guns cause heartbreak. How do you ensure your test doesn't worsen urban violence? Her question struck at the heart of those worried about real-world consequences, tensing the courtroom audience. Kennedy turned to Sotomayor, his gaze sincere. Justice, I grew up near New Orleans, and I know that pain. But taking guns from honest citizens doesn't save lives. My test requires states like Louisiana to focus on dangerous acts, like carrying with criminal intent, rather than punishing everyone. I've reviewed data from open carry states like Maine. Violence doesn't rise because their laws target criminals, not citizens. Louisiana could learn from that. He presented a chart, pointing to figures. Only 15% of gun violence in New Orleans involves legal carriers. We need to address the other 85%. Roberts, now fully engrossed in the argument, posed a constructive question, a clear shift from his earlier combative tone. Senator, assume the court adopts your test. How do lower courts apply it without creating conflicts in historical interpretation? The question, rarely posed to a first-time advocate, showed Roberts now viewed Kennedy as a formidable intellectual adversary. Kennedy smiled, a subtle but confident grin. Mr. Chief Justice, my test offers clear guidance. Lower courts can rely on founding-era rulings like State v. Huntley in 1804 from North Carolina, which held open carry as a right absent intent to harm. I've cataloged 25 cases from 1789 to 1860, all consistent on this principle. The court could require states to align their laws with that catalog. No historical precedent, no valid law. He offered a slim document, like a gift to the court. I've prepared this catalog to aid courts. The courtroom buzzed. A reporter whispered to a colleague. He just handed them a dissertation. Louisians in the gallery exchanged glances, some clapping softly, hushed by court staff. Justice Kagan, impressed but cautious, pressed further. Senator, do you think this test could apply to other constitutional rights, like free speech? Kennedy replied swiftly. Justice, Bruin's historical principle is a strong model. If applied to free speech, limits must stem from founding-era practices, like banning incitement to violence. That's how we keep the Constitution alive. Roberts, showing no trace of doubt, gave a slight nod, a rare gesture. He looked at Kennedy, his eyes carrying reluctant respect. Senator, your argument is thorough. The brief but weighty remark was an acknowledgement that Kennedy had far exceeded expectations. In the gallery, a Louisiana farmer whispered, "That's our man." A reporter from the Advocate noted, "Kennedy didn't just survive, he's leading." The Supreme Court chamber fell into a rare, profound silence, as if the entire space held its breath under the weight of what had transpired. Senator John Neely Kennedy, standing at the podium, closed his legal binder with a calm gesture, his gaze sweeping across the 9 justices. His Louisiana voice, now rich with emotional cadence, rang out like a final proclamation. This court, the American people, from Louisiana's fields to New York's streets, trust the Constitution as an enduring promise. The Second Amendment doesn't just protect the right to bear arms, it safeguards the dignity of a free person. I ask this court to uphold that promise. Kennedy fell silent, the light from the courtroom windows illuminating his face, highlighting his resolve. The justices, from Thomas's pensive expression to Kagan's paused pen, seemed captivated by the moment. Chief Justice John Roberts, who had begun with sharp skepticism, now sat upright, hands clasped, his gaze no longer challenging but deeply contemplative. In the gallery, Louisianans, farmers, shopkeepers and NRA members exchanged glances, their hearts racing with pride. A reporter from the Advocate shook her head, whispering to a colleague, "Never seen anything like this." No applause, no murmurs, only silence, a reverent silence for an argument delivered with undeniable force. Kennedy, sensing the atmosphere, gave a slight bow, a humble but meaningful gesture, then returned to his seat. As he left the podium, a court officer lingered, as if reluctant to break the moment. Justice Barrett, still holding her pen, jotted something down, while Justice Alito gave a subtle nod, as if affirming what he'd just witnessed. Roberts, breaking the stillness, spoke, his voice now free of its earlier edge. "Senator Kennedy, thank you. Your argument has given this court much to consider." The brief words carried weight, a tacit admission that Kennedy had not only met the challenge, but reshaped the dialogue. The audience stirred softly, some Louisianese smiling, while a National Review reporter scribbled, "Kennedy makes history." The attorney for Louisiana, a middle-aged man in a gray suit, took the podium next, but the atmosphere had shifted entirely. He began his argument, citing gun violence statistics and state regulatory powers, but his voice lacked conviction. The justices, still absorbed by Kennedy's performance, asked questions with tepid interest. Justice Sotomayor inquired about the Louisiana law's impact on public safety, but the attorney's response, repeating generic points, fell flat. A reporter whispered, "They're fighting a ghost." When the state's attorney concluded, Kennedy's presence still lingered in the courtroom. The court officer announced the end of arguments, and people began to leave, but no one rushed. Louisiana farmers gathered in the hallway, buzzing with discussion. "He spoke for us," an older man in a checkered shirt said to a friend. A young woman, an NRA member, snapped a photo outside the court, posting it online with the caption, "Kennedy defends our rights." A reporter from The Advocate hurriedly interviewed a lawyer from the gallery, who remarked, "I've seen dozens of arguments, but no one's done what Kennedy did today." In the courtroom, as the justices left their seats, Justice Thomas, rarely chatty post-session, turned to Barrett and said something, prompting her to nod. Roberts, gathering his papers, glanced toward Kennedy's former seat, his expression inscrutable yet thoughtful. He had expected to easily unsettle this politician, but instead, Kennedy had turned the Supreme Court stage into a showcase of legal brilliance. An aide near Roberts overheard him mutter, "We just saw something extraordinary." In the hallway, Kennedy, now surrounded by supporters, remained humble. A Fox News reporter stopped him, asking, "Senator, how did it feel to go toe-to-toe with Chief Justice Roberts?" Kennedy chuckled, his trademark Louisiana grin. "I didn't come here to fight anyone. I came to speak the truth about the Constitution. If the court heard it, that's enough." He declined further questions, walking off with the Louisianans, who patted his shoulder like he was a hero. In the now empty courtroom, a staffer cleaning the podium picked up a paper Kennedy had left behind, a handwritten note reading, "The Constitution belongs to the people, not the government." The small paper, though simple, symbolized what had just unfolded. A man from Louisiana, underestimated, had stood up and commanded the Supreme Court's attention. That moment, though no ruling had been issued, was already historic, not just for its legal argument, but for proving that intellect and preparation could shatter any prejudice. Reporters began leaving the court, carrying notes that would soon become headlines across America. From The Advocate to CNN, Kennedy's story spread, not just as a legal triumph but as a lesson in never underestimating someone based on appearances. 6 weeks after the historic argument, the Supreme Court issued its ruling in Dupree v. Louisiana, shaking both the legal world and the American public. The atmosphere outside the court on announcement day was electric. Louisianans, from Delta farmers to NRA members in New Orleans, gathered before large screens in Baton Rouge, awaiting news. In a small local cafe, a group of LSU law students fell silent, eyes glued to a live broadcast. Reporters from The Advocate, Fox News, and dozens of others crammed into the court's press room, ready to cover a ruling that would shape open carry rights. When the opinion was released, the nation paused. By a 7-2 vote, the court struck down Louisiana's open carry restriction as a violation of the Second Amendment, citing New York State Rifle and Pistol Association v. Bruin. Chief Justice John Roberts, in a surprising move, authored the majority opinion himself, a decision observers saw as a tacit nod to Senator John Neely Kennedy. Roberts' 35-page opinion, sharp and clear, opened with a bold declaration. The Constitution protects an individual's right to openly carry arms for self-defense, and state restrictions must align with historical tradition. Louisiana's law fails this standard. Roberts adopted Kennedy's three-part framework as the ruling's foundation. He wrote, "The right to openly carry, absent a compelling and proven public interest, is central to the Second Amendment. The government must provide specific evidence of harm, and any restriction must be rooted in historical practice." He cited State v. Nunn 1846 and other cases from Kennedy's catalog, praising the meticulous research that clarified the founders' intent. A rare footnote acknowledged Kennedy's contribution. The court is grateful for the profound preparation of plaintiff's counsel, which illuminated the historical principles shaping today's ruling. Justice Clarence Thomas, in a separate concurrence, went further, calling for scrutiny of all gun laws lacking historical precedent. He wrote, "The Second Amendment is a shield for liberty, and states cannot erode it with modern regulations lacking foundation." His brief but pointed opinion cited the 1792 Jefferson letter Kennedy had mentioned, a detail that stunned scholars. Justice Sonia Sotomayor, while joining the majority, voiced concerns about urban impacts. She wrote, "This ruling upholds constitutional rights, but states like Louisiana must find ways to curb gun violence in vulnerable communities like New Orleans." She praised Kennedy's data, emphasizing that targeted solutions, not blanket bans, are the path forward. The two dissenting opinions came from Justices Elena Kagan and Stephen Breyer, arguing that the ruling extended gun rights too far, potentially hindering states' ability to ensure public safety. Kagan wrote, "History matters, but modern context cannot be ignored." Yet even the dissents acknowledged Kennedy's compelling case, with Kagan noting his impressive preparation. The ruling swiftly ignited discussions across America. In Louisiana, joy erupted. At a small square in Lafayette, People held signs reading "Kennedy did it" and "Second Amendment lives." On social media, hashtags Kennedy wins and Second Amendment soars trended, with millions viewing clips from the argument. An NRA post read, "Thank you, Senator Kennedy, for fighting for our freedom." Meanwhile, gun control groups like Everytown for Gun Safety expressed concern, urging states to craft compliant laws carefully. The legal world was rocked. At Georgetown Law, constitutional law professors immediately added the ruling to their curriculum, calling it a turning point in Second Amendment interpretation. A SCOTUS blog analysis stated, "Kennedy didn't just win the case, he reshaped how the court approaches legal history." Inspired Louisiana law students began hosting constitutional rights workshops, many dubbing Kennedy the legal hero of our time. Roberts, in a rare moment, closed his majority opinion with a poignant reflection. "This case reminds us that our judicial system is enriched by diverse perspectives, and legal truth can shine from unexpected sources." Though Kennedy wasn't named, everyone knew who he meant. At a small Baton Rouge diner, as news of this passage spread, an elderly farmer present at the argument raised his coffee mug, saying, "He showed the country Louisiana's more than swamps and jazz." The ruling's immediate impact stretched beyond the courtroom. Louisiana promptly repealed the struck-down law, and other states from Texas to Montana began reviewing their gun regulations to avoid lawsuits. Groups like the NRA reported surging memberships, while conservative lawmakers hailed Kennedy as a trailblazer. The Louisiana state legislator said on TV, "Senator Kennedy brought the Constitution back to the people." Kennedy, true to form, remained humble. When a CNN reporter asked about the ruling at a New Orleans event, he smiled. "I just did a lawyer's job, speak the truth and trust the Constitution. This ruling isn't mine, it's the American people's." His simple yet powerful words echoed across news broadcasts, cementing his image as a defender of liberty. The Dupre v. Louisiana decision swept America like a storm, leaving a lasting mark not only in legal circles, but in the hearts of people from small Louisiana towns to major cities. At a Shreveport community hall, residents gathered, holding handmade signs, "Freedom wins," and "Thank you, Kennedy." Zydeco music from a nearby bar mingled with lively gun rights discussions. On social media, clips of Senator John Neely Kennedy's argument garnered millions of views, with trending hashtags. A Baton Rouge account posted, "Kennedy showed the nation the Constitution isn't just paper, it's our strength." The ruling's impact spread rapidly. Within months, 5 states from Arizona to West Virginia amended their gun laws, lifting open carry restrictions to align with the new Supreme Court standard. Organizations like the NRA reported a 20% membership surge, with everyday citizens from mechanics to teachers joining to protect their rights. In Louisiana, a coalition of small business owners in New Orleans held workshops on legal gun carry, inspired by Kennedy's argument. A grocer, once fearful of robbery, told a local station, "Thanks to Kennedy, I know I can defend myself without the law punishing me." Academia buzzed. Law schools from Tulane to Virginia incorporated the Dupre ruling into curricula, viewing it as a milestone in Second Amendment interpretation. A Tulane professor remarked on a legal podcast, "Kennedy didn't just win a case, he redefined how we view constitutional history." Law school applications in Louisiana rose 15%, with many young students, especially from rural areas, citing Kennedy's path. A freshman at Louisiana State University wrote in an admissions essay, "I want to be a lawyer to defend people's rights, like Senator Kennedy did." Seizing the chance to turn victory into lasting action, Kennedy founded the Kennedy Liberty Institute, a nonprofit to provide legal aid for constitutional rights cases, especially gun rights and free speech. Its first office opened in Baton Rouge, staffed by young lawyers, many former students of Kennedy from his law teaching days. The institute soon received hundreds of aid requests nationwide, from farmers facing land seizures to students disciplined for political speech. At the institute's launch, Kennedy said, "The Constitution is a guiding flame. Our duty is to keep it burning." A notable event occurred at Tulane University, where Kennedy and Chief Justice John Roberts appeared together at a civic education forum. The auditorium's atmosphere was warm yet formal, packed with students and lawyers. Roberts, with his calm demeanor, opened, "The Dupre argument taught me that legal excellence can come from anyone who brings truth and dedication." Kennedy replied, his voice gentle but magnetic, "Mr. Chief Justice in Louisiana, we believe the Constitution doesn't need a Harvard accent. it just needs the people's heart." The remark sparked thunderous applause, and their handshake became a symbol of reconciliation and mutual respect. Media amplified the story. A Times-Picayune article detailed Kennedy's legal journey, from studying founding documents at Oxford to teaching law in Louisiana, inspiring students by blending history with practice. It quoted a former student. "He always said the law serves people, not rules them." This, alongside CNN and Fox News analyses, made Kennedy an icon of perseverance and intellect. Kennedy's legacy, through Dupre, proved one underestimated person could reshape how a nation views its rights. From Louisiana's red dirt roads to the Supreme Court's halls, he showed that law defended with preparation and conviction can be a torch for all. The story of Senator John Neely Kennedy in Dupre vs. Louisiana reflects core American values today: perseverance, faith in the Constitution, and overcoming bias through talent. In modern America, where debates over gun rights, individual liberty, and the judiciary's role rage, Kennedy's journey from a politician dismissed by Chief Justice Roberts to the shaper of a Supreme Court ruling offers a profound lesson. He proved meticulous preparation, from studying founding-era militia laws to analyzing precedents like Heller and Bruin, can transform a legal system. His founding of the Kennedy Liberty Institute to support constitutional cases underscores the importance of practical action after theoretical wins. The practical lesson for Americans today: don't let bias or background limit your potential, but success demands relentless preparation. Whether a Louisiana law student or a citizen fighting for rights, learn from Kennedy, study deeply, speak truth, and act with conviction. In a polarized society, where gun and liberty debates are often emotion-driven, approach like Kennedy, use data and reason to persuade. Engage in community forums as Kennedy did at Tulane, to build shared understanding. Finally, defend the Constitution as he did, not just with words but through action, because freedom in America isn't automatic, it must be preserved daily. Thank you for following Senator Kennedy's journey to defend the Constitution. Subscribe now to not miss inspiring stories of freedom and justice, and see you in the next video.